Hello friends, welcome back to Genius Books. I am Vinod Kadkor, IAS monk. Hope you remember the meaning of preamble. Those who have not seen my previous video, see this is King Penguin. Preamble is, the meaning of preamble is walk before. Penguin is walking before this ocean. Okay. That preamble word originated from preambulus. It is a Latin word. This all we saw in our previous video. Now let us move on to the part 2 of preamble. Okay. This structure, the beautiful 3D graphics created by Dr. Rajeshwari Kasturi. I told you about her in my previous video. Okay. She is Additional Director General. She is here at her office in Delhi. Government of India, Finance Ministry, Income Tax Department. She is Additional Director General. She created this wonderful 3D graphics. It is going to be there with us all along till I finish this constitution part. Okay, because it's very useful for us to master our constitution in few days. Okay, now today we are going to have insights about the evolution of doctrine of basic structure. Okay. What do I mean by doctrine? Doctrine is a belief or set of beliefs held and taught by a church or a political party or a judiciary. Okay. So in our judicial system or in any judicial system, any countries, they use certain tools to construct their judgment, and those tools are called doctrines in judicial system. So this basic structure is one doctrine. Okay, in Keshavananda Bharati case, the 13 judges bench record that was actually. So judges used this doctrine of basic structure to construct the judgment. So it's a landmark judgment, this April 24th, 3 months back. That was 50th year of Keshavananda Bharati case judgment. You know all about it. It's a very famous case, and quite a few questions have been asked in prelims previous exams. Now we have to move to next level. Okay. So in coming years they might ask about these doctrines. Okay, in Keshavananda Bharati case, which doctrine was used? Or in Golaknath case, which doctrine was used? Or in Shankari Prasad case, which doctrine was used? They're all next level. Okay, so we have to look into these doctrines. For that, let us go. It's a beautiful evolutionary story actually, how this doctrine of basic structure established. Okay. So for that, let us begin with our first Republic Day. That was 26 January 1950. So when our constitution came into existence. So all states, they were very enthusiastic, very eager to implement so many reforms, particularly land reforms, because they wanted to abolish the Jamindari system. Jamindars, they acquired thousands of acres of land during British rule. So now we are free, we have our own system, we have our own constitution, so we can bring so many reforms. That was the kind of atmosphere during the initial period of our political system. Okay. So, various states they brought land reforms acts, Jamindari abolition acts, particularly Bihar, Madhya Pradesh, and Uttar Pradesh. So they brought these land reforms. Basically, they are agrarian reforms. Agrarian is connected to agriculture. So they wanted to acquire the excess land held by the jamindars, and the government wanted to redistribute those lands among poor farmers and laborers. Okay. So what happened? Patna High Court, in case of Bihar Land Reforms Act, Patna High Court it held that Bihar Land Reforms Act was unconstitutional, whereas Allahabad High Court and Nagpur High Court, what they did, what the verdict, what the judgment they gave, Land Reforms Acts or Jamindari System Abolition Acts, they are all valid. There is nothing unconstitutional in it. So, Patna High Court gave different judgment. This Allahabad and Nagpur High Courts, they gave different judgment. So, there was a kind of confusion among our courts. To remove this confusion, Union government, central government, what it did, it brought one amendment, first amendment, that was first amendment to our constitution. Okay. Remember, during that time, it was just a provisional parliament, whatever constituent assembly, which was constituted to form our constitution. That itself acted as our first parliament. It was a provisional parliament because after deciding all the things, elections for Lok Sabha and Raj Sabha also, elections were to be held. It was not yet done. So whatever existing that time, it was a provisional parliament. So it brought one amendment, first amendment that was, and it added ninth schedule to our constitution. In that ninth schedule, all the state government, these land reforms or Jamindari system abolition acts, they are all inserted in ninth schedule, and this ninth schedule was given protection from judiciary. That means no Jamindar should go to court claiming that all the land reforms acts are unconstitutional. Fundamental rights were under attack. You should not claim like that. That was the idea to bring that First Amendment Act. So it's all about fight between fundamental rights and Parliament's amending power. Okay. So it's all fight between fundamental rights and amending power of Parliament. Fundamental rights, Article 13, particularly Section 2. Amending power of Parliament, it is Article 368. So whatever you have read or whatever you know about all these famous cases, Shankari Prasad, Sajjan Singh, Golaknath, and then Keshavananda Bharati, these are all nothing but fight between fundamental rights and amending power of our Parliament. You just remember this one line one line explanation. So with this, fundamental rights versus amending power, just remember these two words. You can analyze all cases, all Shankari Prasad, Sajjan Singh, Golaknath, Keshavananda. Okay, so the crux of the matter, all these cases is FRs versus amending power of Constitution. Article 13 versus Article 368. So just these two terms you remember, so that you can analyze all those important cases. Okay. Now, in case of 1951, let me go to some blank page so that I can. So, Shankari Prasad case. This is 1951. Okay. Shankari Prasad was a Jamindar from Bihar. Okay. He, after central government, union, parliament, after it brought First Amendment Act, Shankari Prasad went to Supreme Court, claiming that it was attack on his fundamental right. Okay. So, fundamental right, particularly, unfortunately or fortunately, Article 31, it is right to property. Okay. This was also fundamental right, guaranteed by our constitution. So, Shankari Prasad argued that to have property is my right, fundamental right. How can you take away my lands? Okay, with the help of Land Reforms Acts or Jamindari Abolition Act. You cannot do that because fundamental rights, Article 13, Section 2, what it says, no law, remember this, no law can take away the fundamental rights of citizens. That is Article 13. So, in that fundamental rights, Article 13, this term is used. That means no law can take away or abridge or modify fundamental rights of citizens, whatever fundamental rights provided in this constitution. So, Shankari Prasad argued that to have property is my right, it is fundamental right. So, according to Article 13, no law can take away my right. That is a simple argument. So, what about Article 368? It speaks about amending power of Parliament. So, Parliament can, under this Article 368, Parliament can amend any part of Constitution. Whereas Article 13 says no law can take away or abridge or modify fundamental rights. These two are conflicting to each other. So in this case, what the Supreme Court said, it used the doctrine of harmony. So we are looking at doctrines as well as evolution of basic structure. So doctrine of harmony. So this doctrine is used as a tool to construct their judgment. So it's so beautiful how judges work, how they arrive at that particular judgment using these tools. Okay. So doctrine of harmony means whenever there is conflict between any two provisions of Constitution, we have to find a harmonious path. So here conflict between 13 and 368. So law, whatever term used in this Article 13, no law can take away the fundamental rights of its citizens. No law can modify any of the fundamental rights given in this Constitution. So, but 368 amending power, Parliament can amend anything. It can amend fundamental rights also. That was their argument. So what court did? It found a harmonious way. So it used doctrine of harmony and it said whatever the term or word used law in Article 13 is just ordinary law, whereas Article 368 it is amending act. It's not an ordinary law. It is an amending act. So there is no conflict between this law and amending act. It is a constitutional law. Article 13 speaks about just ordinary law, whereas Article 368 is constitutional law. So that ordinary law it is not concerned with this constitutional law. So court upheld that first amendment, ninth schedule. So whatever land reform, Jamindari abolition acts enacted by different state governments which were added in ninth schedule, they are protected, they are valid, they are very much constitutional. Parliament can use this Article 368 and amend any part of constitution. That was the judgment given by the court. Okay. This is Shankari Prasad case. So amending power of Parliament is supreme. That's what it indicated. Okay, now moving on to next case. That is Sajjan Singh. Sajjan Singh was a prince. He was prince of Rajasthan. He was ruling princely state of Ratlam. So again, central government, union government had brought some amendment, that is 17th amendment. Through that amendment, what it had done, it has defined under property, right to property, it has defined term estate also. So here, what they have done, they have modified fundamental right. Okay, this was 17th amendment. So what Sajjan Singh did, okay, Parliament has amending power under Article 368, but if without using Article 368, if they are modifying fundamental rights, can it amount to the amending power of Parliament, or what? Or just bringing some modification to fundamental rights? Is that okay? Because Article 13, Section 2 says that no law can modify or take away fundamental rights. Through 17th Amendment, central government, union, parliament, it has brought, it modified and described a state. So it has modified fundamental rights. It has not used Article 368. So in this case, can we take the help of Article 13 where it says no law can modify or take away the fundamental rights, whereas now government has modified this fundamental right and brought some estate, definition of estate they have described. So it's a modification. According to Article 38, no law can modify fundamental rights. So this was the question there. Here the very interesting part is, again, Supreme Court decided, it took the help of, it used the tool, Doctrine of Pith and Substance. Okay, with the help of this doctrine, Supreme Court ruled that there is nothing wrong in modifying this particular fundamental right. Okay, it is very much constitutional. So this pith means essence of something, that is this particular issue. Substance is substance of that something. Here essence of this Article 13 is that law, okay, and modification. What is the substance? Whether it amounts to 368 or not. If it's not amounting to 368, then how can they modify this fundamental right? That is the substance. So using this pith and substance doctrine, Supreme Court said there is nothing wrong in modifying this fundamental right, because it actually protects fundamental rights. So protection is different, modification different. So there is nothing modified here. It enhanced, it protected fundamental rights. That was the verdict given by Supreme Court. So in these two cases, in Shankari Prasad and Sajjan Singh, these two cases, fundamental rights versus amending power. Article 13, Article 368. So in the fight between 13 and 368, so 368 was the winner. Okay. Just remember all these cases, 13 versus 368. What is 13? What is 368? I explained it to you. Okay, fine. Now, in both the cases, Shankari Prasad as well as Sajjan Singh, winner was 368. Next comes the most important case of Golaknath. Okay, Golaknath. Golaknath brothers, actually Henry and William, they were from Punjab, Jalandhar district. Okay, they had some around 500 acres of land. Again, same thing. Punjab Tenancy Act and Land Reforms Act. Through that, what Punjab government did, they whatever excess land Golaknaths were having, they acquired it. They gave only around 60 acres of land to them. Remaining, they just distributed among the poor farmers and laborers like that. So Golaknaths, what they did, they went to court and this is a very interesting part. The pendulum had swung to the extreme end. Okay. So what happened in Golaknath case, this Supreme Court reversed its earlier judgment. So what it did, to put it in simple way, in case of Golaknath case, the fight between fundamental rights and amending power, 13 versus 368. Court held that 368 you cannot use according to your will. Fundamental rights is most important, so it upheld the fundamental rights. You cannot modify or amend or take away the fundamental rights. That was the judgment given by Supreme Court. Okay, so 368 was eclipsed by fundamental rights. So 368 was eclipsed by 13. So this doctrine is Doctrine of Eclipse. Eclipse means obstruct, a shadow. So 368 was obstructed by or shadowed by 13. So total reversal. That's why I told you pendulum has swung to the extreme, other extreme. Okay. And again one more here, doctrine of prospective overruling. Doctrine of prospective overruling. These both are used in this case. Okay, doctrine of prospective. You understood what is doctrine of eclipse. Now, what is doctrine of prospective overruling? As the name itself indicates, see, they said fundamental rights are supreme. Under Article 368, Parliament cannot modify or take away the fundamental rights. So, what are previous cases? So, the previous cases, this new judgment or new rule will not apply to previous cases. So, all the previous judgments or rules, they were valid till this date. That means from now onwards they are not, this prospective overruling is from now onwards, from this day. Whatever new rule will come, for only for those this will apply, not for the previous cases. That's what prospective overruling. So otherwise what would have happened? You are supposed to give all the acquired lands back to them. Okay. So it's not fair after so many years. See, Shankari Prasad case was 1951. Okay. And who is that? Second one, Sajjan Singh, it was 1964. This Golaknath case is 1967. So now today, in 1967, judgment has come saying that all the fundamental rights are important. You cannot change or modify or cancel or take away the fundamental rights. So 368, Parliament cannot amend any part of the constitution according to its will. So if you apply this rule for the previous cases, it is not logical. Okay, so this tool, prospective overruling, is applied. So this doctrine of prospective overruling and doctrine of eclipse, both these are used in case of Golaknath 1967. Okay, now coming back to, see, the thing is, after this what happened? It was actually Golaknath's case judgment was very shocking for executive and legislature. Okay, there are three organs which our constitution has provided, right? One is legislature, other is executive, and third one is judiciary. So with Golaknath's judgment, judiciary has given a shock to executive as well as legislature, because under Article 368, if you have no power to amend, then Parliament, what it can do? It cannot bring any, especially with respect to fundamental rights. What about property right? So from this judgment onwards, land reforms and all that, they were not going to be executed. So what happened to your social justice, economical justice? You cannot take the excess land from jamindars, landlords, and distribute them among poor farmers. So it is a blow to our government's social justice idea or whatever, that equality and all those things. So because of all this, with this background, now what happened in Golaknath case, Parliament's power is curtailed. Okay, what what the Parliament or all MPs and legislature, what are they supposed to do? In the meantime, 1971 general elections to Parliament, Lok Sabha, it held. After that, what the government, Indian government, Parliament, what it thought, we have to do something. We have to undo the Golaknath judgment. For that, what it brought again so many amendments. Okay, it brought number of amendments protecting their amending power. So again, with these amendments, Keshavananda Bharati, he went to Supreme Court with the help of famous lawyer at that time, Nani Palkiwala. He advised him and the case went to Supreme Court. Keshavananda Bharati is Kerala, that Kasaragod district, Edanir, one place is there. There, Mutt, that is monastery you can say. So Keshavananda Bharati Mutt, it is that Edaniru is place in Kerala, Kasaragod district. So he went to Supreme Court challenging all the new amendments. So in Keshavananda Bharati case, it was a 13 judges bench, constitutional bench, record number of judges. So they gave judgment 7-6. So out of 13 judges, 7 is majority judgment, this is minority. So 7 judges, they said that amending power of Parliament, that is Article 368, is supreme. Fundamental rights, they are also supreme. Okay. But Parliament under this Article 368 can amend any part of this Constitution. Any part. Okay. So the court, Supreme Court, it is trapped under its own web. Okay. Since 1951 till this 1971 and 70, this Keshavananda Bharati cases, 1972 went to court and judgment day was 24th April 1973. Okay, so from 1951 to 1973, almost 22 years. So first earlier they said 368 is supreme, 13 it is just a law, ordinary law. So now again the judgment is reversed. So this whole evolution. Okay. So in this case, this Supreme Court, it got trapped itself. Okay. Now 368 is, they said amending power of Parliament is supreme. Fundamental rights, they are also supreme. So the conflict between these two, how to resolve this? Then the Supreme Court brandished a master stroke. So what is that? Okay, under 368 you can modify any part of our constitution. Okay, you can modify any part of our constitution, even preamble. Okay, preamble also you can modify, but basic structure of our constitution should not be changed. Basic structure. So this is what the judgment in case of Keshavananda Bharati case. So, at last, we have arrived at a doctrine of basic structure. Okay, this basic structure doctrine, it is actually, the concept was originated in Germany, but it evolved and established in Indian judicial system. Okay, so now long ground had been covered. Okay, since the uh, establishment of our constitution till Keshavananda Bharati case. So in Keshavananda Bharati case, finally the basic structure doctrine was established. Okay. Now what is this basic structure? So Justice Hidayatullah, in previous case also, he was with fundamental rights, okay, all the time. He gave, see, the basic features of our constitution is all embedded in preamble. So Hidayatullah had said, preamble is soul of our constitution. Okay, so this basic structure, it is preamble is epitome of basic structures of our constitution. So that is how preamble was considered as part of our constitution. Okay, in Keshavananda Bharati case, Chief Justice of India (CJI) was Sikri. Okay, he mentioned, see, the thing is, when Constituent Assembly, which formed our constitution actually, that it said, when they adopted this preamble, at the end, after the first reading, second reading of our draft constitution, finally it adopted preamble. Okay, so while adopting that preamble, the President of Constituent Assembly, he said that preamble stands part of our constitution. So it is there in our Constituent Assembly debates and all that. So it shouldn't have been confused in case of Shankari Prasad or all those things. But the preamble is not part of the constitution. This is a different case. That is Berubari. So Berubari case 1960. In Berubari case, Supreme Court again, it was a blunder actually by Supreme Court. What it said, preamble is not part of the constitution. Why it said Berubari, some enclaves in West Bengal, Jalpaiguri district. So during partition of India and Pakistan, or boundary commission, Sir Cyril Radcliffe, he demarked our boundary, okay, boundary line. While doing that, Radcliffe included this Berubari region in Indian side. But unfortunately, he forgot to mention it in official records. Because of that, in 1952, Pakistan started claiming that Berubari belongs to them. So that case like that, and ultimately what happened in 1958 September, Nehru, India's Prime Minister Jawaharlal Nehru, and Pakistan's Prime Minister at that time, Firoz Khan Noon, they made an agreement. That was in 1958 September. It is known as Nehru-Noon Agreement. According to that agreement, all the regions of Berubari should be equally distributed between Pakistan and India. That was the agreement. But West Bengal Chief Minister that time was B.C. Roy. And West Bengal people, they did not accept this agreement. How can we give our part? We are a sovereign country. Okay, we the people, that is what. So without the people's consent, how can Nehru can give our land to some other country. We're a sovereign country. So we the people, that's what the preamble says. So according to that, we are not going to give our land to some other country. Okay, that was the argument. So because of that, the preamble, whether it is part of constitution or not, that question came in Supreme Court, and Supreme Court gave judgment that preamble is not part of the constitution because our legislatures, MPs, they don't draw any power from it. Preamble won't give any power to them. Neither it gives power and nor it limits their power. So it is not part of the constitution. It is just a key to understand or open the minds of our constitution makers. That's what Supreme Court said in Berubari case. So because it said preamble is not part of our constitution, that question was there. It was resolved in Keshavananda Bharati case, where it is considered that preamble is very much part of our constitution. Okay. Parliament under Article 368 can amend any part of constitution. Preamble can also be modified, but basic structure should be maintained. It should not be changed. That's what Supreme Court meant. That is how this doctrine of basic structure evolved. So I hope I covered most of the things what I wanted to cover. Now let us one more thing. See, we have seen most of these doctrines. Now one more is left. Okay. There are so many, but these are important. That doctrine of pith and substance, it was Canada's. Okay. Then doctrine of prospective overruling, it is from US. Okay, now but doctrine of basic structure, it is very much Indian because it evolved in India very nicely, even though it has its root in Germany. Okay, now two more you can say. Doctrine of Liberal Interpretation. Doctrine of Strict Interpretation. Okay. Remember all this because so far they have not asked any question on these doctrines. They might ask in coming exams. So this is how you have to evolve yourself. See the question papers, see the previous question papers, what they have asked, next what they are going to ask. So that kind of approach you have to develop. That's what I am telling you. You have to evolve yourself in your preparation. Okay. They cannot keep asking on Keshavananda Bharati again and again. Okay. So that basic structure concept, they have asked some one or two times. Now what about doctrines, other doctrines? Okay, so you please give proper attention to these doctrines. Only these, there are so many in legal. We are not going to become legal pundits, okay? But we should know at least basic things. These are all basic things connected to very prominent cases. So you have to look into this. Other than this, they will not ask any more deeper questions, okay? Now what is the doctrine of liberal interpretation? Doctrine of liberal interpretation, as name indicates, liberal. So normally, can you guess where it will be applied? This tool it is used by judges way to construct the judgment. This doctrine is used in case of, for example, say animal cruelty. Okay, some things they have to give judgment on this issue, animal cruelty. In that case, they have to interpret liberally so that we can advance our thinking and our legal system like that. So that is liberal interpretation. What about doctrine of strict interpretation? That is about strict interpretation. In case of crimes or criminals, now you are hearing about this Manipur very shocking one event. Okay, so criminals in such cases, court will interpret in strict way. There should not be any. We should not give any liberal. There should not be any liberty given to criminals. So criminals and tax laws. So in such examples, judges will use strict interpretation. In animal cruelty and other such things, they interpret liberally. Okay, so I hope you understood. Let me give one last example so that you will understand these two interpretation in a more better way. Okay, in my last video I had said Lakshmikant has used for amend. See, our preamble, our preamble originally it had 81 words. Okay, original preamble. So after 42nd amendment, okay, 1976, some words added to our preamble. How many words? Lakshmikant has given, a very famous book referred by all toppers and advised by all toppers to read Lakshmikant. It's the Bible of our Indian Constitution and polity. So everybody will have that book only. Of course, it's a good book. And I am saying he has given these how many words added to our constitution or preamble. Earlier there were 81 words. After 42nd amendment, Lakshmikant in his book about preamble chapter, he has given 3 words added. Okay, what are those words? Let me show you that slide here. Okay. So Lakshmikant has given these 3 words: socialist, secular, integrity. Okay, 1, 2, 3. In my previous video, I told you he has given wrong, and I said 5 words added. Okay. I did it deliberately. Okay, I tell you why. Actually, words added were 4. And also added. And is it not a word? You have to consider that as a word. When you consider even a or the or the, when you pronounce the, that is a different thing. I tell you later if situation demands. So these are all words. So and is also a word. In that case, through 42nd amendment, 4 words added to our preamble. Now, total number of words in preamble 81 plus 4, 85. Then why did I say 5? Why Lakshmikant has given only 3? So, I have to give judgment about this. Okay. I am not saying that Lakshmikant is wrong. I am just interpreting here. How we can interpret using different doctrines. Okay, I am using those doctrines here in this case. So, doctrine of severability. That means severability means you can cut some provisions and retain other provisions. That can be done. So, fifth word, there is no fifth word actually. I said it deliberately. So, you can cut this. I am applying doctrine of severability. Okay. Now we are left with 4 words. Now Lakshmikant missed and. So here he has applied doctrine of liberty. Liberal interpretation. Okay. Lakshmikant, he interpreted in liberal way. He and is okay, it's not such a prominent word compared to socialist, secular, integrity. So he left out and, that is doctrine of liberal interpretation. He liberally left it off and okay, chalega. So what I want to apply doctrine of strict interpretation, and is also one word, I have to consider it. So doctrine of strict interpretation, it goes word by word, in fact letter by letter. Okay, no criminal, no, there should not be any leverage to criminals. Strictly we have to apply each and every word of the law. So here and we have to include it, that is doctrine of strict interpretation. Okay. So, but Lakshmikant used doctrine of liberal interpretation. He left out and. This is the thing. So, because of this, to make you understand about these doctrines, I used this example. Okay. However, I am not against Lakshmikant, and don't take me wrongly. Because all Lakshmikant fans may say object, but this is the thing. I am giving you facts. Okay, you read Lakshmikant, it's a good book, but it is not enough because he has not explained much about these doctrines. In coming years, definitely they will ask about doctrines. So this is how you have to develop your preparation, evolve through the system. Okay, not just take Lakshmikant and read, take NCERT books and read. So give other things for chance. Okay, prelims, you have to qualify in prelims. It's a game of lottery, in fact. If you don't prepare properly, out of all those about 10 lakh, 8 lakh candidates, some 15,000 will be recommended for mains. It's a game of lottery, in fact, if you are not prepared properly. Okay, so this is the thing. I just showed you how to apply different doctrines. That is how judgments are constructed using different doctrines. Hope you understood this part. There are so many things about preamble only. I can say so many things. So in next part 3, we are going to explore other interesting parts of our preamble. It is based on Nehru's objective resolution, that you know. But if you see the final form, final wordings of preamble, it is such a beautiful, it is written in such a poetic way. Who did that? Nehru's objective resolution, of course it contains all these words, but it has represented in different form. If you look at the final preamble, it gives you the kind of the majestic way of presenting our preamble. So who actually wrote the final preamble, and who all objected, all those Constituent Assembly members. That Constituent Assembly was in fact first unofficial parliament, you can say, because they were not elected through general election. Only after 1952, after 1951, general election, first general election was held in 1952. So after that, actual parliament came into existence. Before that, this Constituent Assembly, it was a provisional parliament, you can say, or first parliament, unofficial parliament. So there's so many wonderful debates, Preamble, see some member, he brought an amendment. You have to include the word God before the start of this preamble. So people, you are discussing, and so it was a wonderful discussion. Finally, it got rejected. It was so embarrassing for so many members. We have come to such a level that we are discussing about God and we have rejected that. My God, so many things. I tell you in my next part. So I think today it's enough, and see you very soon in my next video. Hope I am giving you good insights and creating interest in you to read more about our constitution. Okay. Fine, then I'll continue in my next video.